Pada pagi ini bersama-sama saya dalam PC pada pagi ini ialah Presiden MTUC Saudara Khalid, pengurusi kepada IR MTUC Saudara Robert, Saudara Kula, Saudara Syed dan Saudara Rosli, Vice President daripada MTUC, termasuk kawan-kawan Vice President Bala daripada MTUC. Pada hari pertama, iaitu hari Isnin, MTUC telah mengadakan satu protes dekat luar Parlimen supaya pindaan akta kerja akan ditarik balik oleh pihak Parlimen, khususnya pihak Menteri. Pada petang yang sama, Menteri telah mengatakan bahawa pindaan ini akan membawa perlindungan untuk pekerja dan oleh kerana itu kerajaan BN akan meneruskan dengan tindakan untuk membawa bil ini supaya kita bahas pada pagi ini. Tetapi apa kita akan bincang pada hari ini ialah kerajaan mengatakan bahawa pindaan ini akan membawa kepada perlindungan dan jaminan kerja untuk pekerja. Tapi kita di sini percaya bahawa ini tidak semestinya. Untuk membuat pernyataan pertama, saya minta Saudara Khalid supaya memberi beberapa pandangan.
Ya, terima kasih YB Charles. MTUC mendapati bahawa cadangan pindaan kepada Akta Kerja 1955 adalah satu tindakan yang menjurus kepada impak yang negatif kepada kaum pekerja. Terutamanya apabila kontraktor for labor ditimbulkan di dalam pindaan tersebut. Kami rasa masalah kontraktor for labor ini akan merugikan kaum pekerja. Sebab apa yang berlaku beberapa tahun yang lepas, 10-20 tahun yang lepas, pekerjaan dalam kontraktor for labor untuk kontraktor for labor ini banyak menjurus kepada eksploitasi pekerjaan. Kebajikan pekerja tidak dijaga dan pekerja-pekerja ini hilang hak. Dia punya security of tenure hilang. Hak untuk menjadi ahli dan menubuhkan kesatuan juga hilang. Dalam keadaan ini, dari segi mana kita lihat apabila pihak kerajaan mengatakan pindaan undang-undang Akta Kerja ini akan memberi perlindungan kepada kaum pekerja. Ini akan menjurus kepada sektor-sektor yang formal menjadi tidak formal. Dan ini tidak akan mendatangkan jaminan pekerjaan kepada kaum pekerja. Justru itu pihak MTUC telah beberapa kali memohon supaya bil ini di-withdraw, ditarik balik dan rondengan seterusnya diadakan bagi memastikan tidak ada kelemahan dalam cadangan pindaan yang cuba dibuat oleh pihak kerajaan. Justru itu saya juga ingin menyeru kepada Perdana Menteri supaya dapat mendengar apa juga rintihan kaum pekerja yang cuba kita suarakan hari ini. MTUC akan menulis pada Yang Amat Berhormat Perdana Menteri untuk satu perjumpaan supaya kita dapat mendeliberasikan apa juga bantahan kita terhadap pindaan kepada Akta Kerja yang akan dibentangkan ni hari. Dan kita mohon sekiranya boleh bil ini tidak dibentang pada hari ini. Ditangguhkan supaya rondengan seterusnya diadakan. Terima kasih.
Terima kasih Saudara Khalid. Pada pandangan saya, bil ini adalah tidak sah. It is an illegal bill. Mengapa saya katakan bil ini adalah illegal? Sebab kita mesti memenuhi, we have to fulfill two requirements in any employment relationship. The first requirement ataupun ciri pertama yang kita harus memenuhi ialah the employer and the employee enter into a contract of service. Contract of service where one person agrees to employ and the other agrees to serve as the worker. So there is a mutual agreement. Itu ciri pertama. Ciri yang kedua, ini yang penting sekali. Ciri yang kedua ialah the employer is the owner operator of the factory. The employer must be the owner operator of the factory. That means the employer must provide the machine, he must provide a place to work, he has to supervise the work, the actual work, and also the profits must also go to the employer. Itu maksud dia, owner operator of the factory. Dengan memperkenalkan konsep contractor of labor, what the government is doing now is that outsourcing companies will become employers. That means if I work in a factory A, if I work in factory A, kalau saya kerja dalam majikan, satu majikan, maka employer saya bukan majikan A tetapi outsource company. So my employer is not the company A where I actually go and work, but is the outsource company that sends me to work in company A. Now this is the implication of the law. Ini adalah implikasi undang-undang itu. So therefore now the principal company iaitu company A is no longer liable. And the new employer is actually the outsourced company. So therefore, what is illegal is now made legal. Itu implikasi pertama. Implikasi kedua ialah penubuhan kesatuan sekerja. These outsourcing companies, dia hantar pekerja untuk bekerja di satu tempat untuk 2 bulan. Selepas itu ambil pekerja itu kepada factory kedua untuk 2 bulan lagi. Tetapi kalau you nak menubuhkan satu kesatuan kerja, if you want to form a trade union, you must be there to get the 50+1. You must get 50+1 for recognition. But if you are moving from factory to factory every 2 months, you will never have recognition. So once and for all, you have doomed the trade union in Malaysia. So trade union can kiss and goodbye, say goodbye, we are finished. That's what I think the implications of it is. Alright? So the minister is telling us that this will memperlindungkan dan menjaminkan hak pekerja. But actually this will actually melemahkan dan actually hancurkan hak pekerja di Malaysia. Kalau kita banding dengan negara-negara lain, Indonesia, Thailand dan Philippines, kita dapati bahawa outsourcing has weakened workers' rights in the factory though. Has weakened, and they got no benefits when they work as contract workers, as outsourced workers. So Malaysia is now doing it, and Pemandu has very clearly said, that this is part of labour sector liberalisation. It's part of labour sector liberalisation or market liberalisation, and therefore it is necessary for workers to be violated like such as this. So tapi yang penting sekali ialah kalau saya kerja untuk company A, untuk majikan A bukan sebenarnya majikan saya. Majikan saya adalah kontraktor yang hantar saya untuk kerja di tempat itu. This is serious though. So kalau saya kena sakit, kalau tangan saya kena potong bila saya kerja, bila saya jatuh kepala saya kena sakit, siapa akan mengambil tanggungjawab? Ini menjadi masalah. So therefore I agree with the minister that outsourced workers are exploited. And dia kata he said didera oleh outsourcing companies. But this is not the law to change. What he needs to change, or what he needs to regulate the outsourced companies, is with the Private Employment Agencies Act 1981. That's what he needs to do. And the government still today hasn't justified why they want to amend the law. And therefore, the minister must come out and say, what is the employment impact assessment on this issue? What is the employment impact assessment to justify to trade unions and also to members of the public why exactly this law is being implemented?
And in this context also, if you talk about contractor for labor, it can also happen this way. When the company A engage a contractor for labor, they will request for certain number of workers, say 10 or 20 people, and this company A would only pay 100 ringgit per employee brought in. And from this 100 ringgit, the employee will only be paid 20 or 30 ringgit each, but the rest goes to the contractor for labor. What kind of middleman system is this? So that means to say this contractor for labor is getting profit just like that, whereas the workers have to work so hard. You see, and on the other hand, if anything happens to the workers, injuries or whatever, or any compensation to be paid, can this contractor for labor is able to pay them when this income only through that? If this is meant by contractor for labor, to be introduced, I think, in most of these manufacturing industries. That is why we are disagreeing with this. And because of these workers under this contractor for labor, they are also some sort like we term as irregular or informal workers. They are not directly under the principal company. They are directly engaged under this contractor for labor, but they are working in the company. Who should be responsible on this? And this contractor for labor workers cannot join or organize union, where the rest of the permanent workers, they have the rights to join and form union. Why must there be, I would say, why discriminate these workers in that way? That is why MTUC strongly does not agree with this proposed amendment, especially on this contractor for labor. It is subject to abuse. The abusers that worries us now.
If this law goes through, that outsourcing companies will be the dominant form of recruitment for companies now to work in. So that means the government supports recruitment through outsourcing companies. That's the message that's coming out. I just want to share with you. This is Maimuna Amuddin. She's a professor at Mara, and she's an expert on law on employment though. And she's got this very interesting passage which is important, which the minister must read before he comes to parliament. In determining the employment status of a worker, the courts have developed a number of tests. The first is, does the employer control when and how the work is done and who does it? Employer, yes, but not the outsourcing company. They don't control. Number two, does the employer provide the tools, raw materials and equipment necessary to do the work? Outsourced companies don't do that. They just supply the labor. It is the principal company that does it though. Now what the law is what this amendment to the law actually will do is, the principal company will not be liable to workers anymore. So that means to say that the government is doing something illegal in actually amending this law though, because it doesn't fit the two requirements. The two requirements is, one, as I said earlier, that the employee and employer relationship has to be negotiated, and number two, the employer is the owner operator of the factory. And the number two actually suggests that you must be an owner operator of the factory though. Otherwise, you cannot be an employer. Otherwise, you cannot be an employer though. Now they're going to make them employers. This is a tragedy though.
Regulate.
All sectors.
Well,
the important thing is there are more than 500 unions in the country. Only one union, namely the National Union of Plantation Workers, insisted the minister is coming to table the bill, which is wrong. You act by the majority. MTUC and other unions are saying no. They compose the vast majority of the workers of this country. And traditionally, all around the world, there is this master-servant relationship. There is an employer and employee. And that the fabric of that is defeated if this thing comes to being. And we have enough problems with people not paying SOCSO, EPF and that kind of thing. And this will make it worse. And what is the Employment Act? An Employment Act is to protect the workers, not to erode their rights. Is this the Minister of Labour or Minister of Anti-Labour? You know, he must understand his function. The whole, if you go back to 1955 and before, all these acts is meant to protect workers. It is to further strengthen the bargaining power of workers, not to weaken the bargaining power of workers. And this is what the government is doing. Is the government listening to the 11 million workers of this country? If they are not, they know what they are for.
So actually, this is actually being pushed by Pemandu. Pemandu's part of its, the way they want to organize the country is to push for liberalization in all the sectors. So they push for liberalization in the financial sector, the services sector, and also in the labor sector. And what clearly in other examples in other countries clearly show is that this will push workers bargaining to the sewer. That's what's going to happen.
Anyway, I'm going to table a motion afterwards to ask that the bill to be referred to a select committee. because I think there are so many ambiguities, so many matters that ought for further and wider discussion. There must be other stakeholders involved. The minister has got it wrong. There's not only one stakeholder, namely NEPW. There are so many other people, including caucus in Parliament and other members of Parliament, NGOs, unions and all that. So I hope when I move the motion, the minister will agree to refer the bill for select committee.
As well as the employment impact assessment as well. Today, afternoon.
It's going to come at 2:30. If the minister agrees, the bill can be deferred. If he doesn't agree, then in the elections we'll make him agree.
But 2 days ago, when the minister gave PC after the MTUC
Protest.
So he said this bill will actually, the government has already limited outsourcing companies' power, and this bill will require the outsourcing company to register with them. So through that, the government can directly monitor and supervise, and in that way protect the rights of the workers.
Thanks for raising the issue. The licensing for outsourcing companies is given by Kementerian Dalam Negeri. There are about 210, I think.
711.
Huh?
There used to be
241 outsourcing companies. When the government gives out the permit to each of the outsourcing companies, they know exactly how many is being given to each of the company. So when the minister tells us that they want to have a check of how many workers are being employed, it's nonsense. It just shows that he's inefficient, he's incompetent, or the ministries are incompetent. Because the KDN is giving out the license. When you give out the license, you know how many workers are being employed. So to say that we want to know berapa bilangan pekerja yang diambil untuk kerja menerusi outsourcing companies, tidak masuk akal. He should know. This is embarrassing for the minister to say, I don't know. That's why we need the bill. Why do you have KDN giving out then? Right? Thank you very much.